Warren sued to overturn his suspension, arguing that the suspension violated his First Amendment rights, among other things. The case was tried over 3 days in December, and on Friday, federal judge Robert Hinkle issued a ruling that overwhelmingly sided with Warren, but yet ultimately concluded that DeSantis still had the authority to remove the prosecutor, or at least that the judge didn't have the power to reinstate him. Quote, Florida Governor Ron DeSantis suspended elected state attorney Andrew Warren, ostensibly on the ground that Mr. Warren had blanket policies not to prosecute certain kinds of cases. The allegation was false. Mr. Warren's well-established policy, followed in every case by every prosecutor in the office, was to exercise prosecutorial discretion at every stage of every case. Any reasonable investigation would have confirmed this. The judge added that Warren's written pledge, quote, could not properly be the basis for a suspension under the Florida Constitution. There was no blanket non-prosecution policies, no neglect of duty, and no incompetence. But the judge also ruled that even though he believed that DeSantis violated state law, the federal court didn't have the jurisdiction to effectively overrule the governor. The court said the 11th Amendment prohibits a federal court from awarding relief of the kind at issue against a state official based only on a violation of state law. The suspension would have occurred even if there had been no First Amendment violation. The First Amendment violation was not essential to the outcome. This order thus directs entry of judgment for the governor. And so the suspension has been upheld, with the prosecutor's next step unclear. The issue may go before the Florida Senate, which is charged with removing officials who've been suspended by the governor. Now, my take. This was a dumb and dangerous move by DeSantis, who is clearly just punishing his political enemy, who was elected and reelected. But the document that Warren signed also did sound like he would refuse to enforce the state law. We decline to use. Why should he be able to do that? Even an elected prosecutor. And what happens now? Let's ask Andrew Warren, the suspended state attorney of Hillsborough County, Florida. Thank you so much for coming back on the show. Really appreciate it. So let me start with that. What happens now?
Well, Dan, thanks for having me. What happens now is that we have a judge who made rulings which are crystal clear, that I did nothing wrong except do my job exceptionally well, that the allegations against me were false, and that the governor broke state and federal law in suspending me. So obviously we didn't get the relief we wanted, even though we got the judgment we wanted from the court. We have a variety of options going forward, but this was never about just me and getting my job back. This was about holding a governor accountable for breaking the law, and that's exactly what we did, to prove that no man, no woman is above the law. And even the governor of Florida, even the governor who wants to run for president, has to follow the law as set out in the state and federal constitutions.
So let me ask you, it sounded in the petition like it was a blanket refusal. I know the judge didn't see it that way. When the language was decline to use our office's resources to criminalize reproductive health decisions, commit to exercise our well-settled discretion, and refrain from prosecuting those who seek, provide, or support abortions. You know, I've taken on some of these constitutional sheriffs, right, who refuse to enforce, be it gun control laws or COVID-related restrictions. Why is this any different? You're basically saying, I'm not going to enforce particular laws in the state the same way these constitutional sheriffs are.
Well, it's a really good question, but the facts matter. And so you're looking at a couple lines in what was a 3-page letter that was really a document outlining opposition to the rush to criminalize abortion after the Dobbs decision came out that overturned Roe. That letter actually had nothing to do with Florida law. Florida law had a different law on the books. It wasn't talked about in that letter. So that letter was a very general statement showing my support for opposition to laws that were being passed in other states. At the same time that I signed on to that letter, I gave a news interview where I was asked, so would you enforce a Florida law on this? And I said, yeah, absolutely. We'd follow the law like we always would. What's ironic is that the governor and his team knew about that. They just ignored it. So, like they ignored a lot of the facts in this in a rush to judgment for a political hit job.
It sounds to me like maybe you're sorry you signed that pledge based on the exact and precise language, because as you mentioned, it was 3 pages long. I did just take a line or two. There's another line in there about gender-related surgery. But It sounds like you regret at least a couple lines in the petition that you signed.
No, I don't regret it at all. I mean, I think it's really important for elected officials to speak out on issues of public concern. We obviously have the First Amendment right to do so, but as an elected official, I should be transparent with my community about my values and where I intend to spend prosecutorial resources. You had mentioned the transgender issue. That wasn't even a law in the state of Florida. The governor suspended me, accusing me of not enforcing a law that doesn't exist.
Thank you for watching. Go to newsnationnow.com to find NewsNation on your cable provider. And don't forget to click the red subscribe button below to get more of NewsNation's fact-driven, unbiased coverage.